Legal dictation 120 words per minute. 5 seconds. Comments. The challenge in the present appeal is to an order passed by the High Court of Judicature at Patna dated 6/2/2013, whereby a writ petition filed by respondent number 41 herein was allowed, holding that the tenant in the premises in question was representing a joint Hindu family, the Bihar State Sunni Waqf Board, and consequently the induction of the appellant as a tenant by the Waqf Board was illegal. Accordingly, a direction was issued to dispossess the appellant from the suit premises and to hand over the vacant possession to the plaintiff. The plaintiff had filed a suit for declaration before the competent civil court, stating that he is a tenant in the suit premises and is entitled to continue in the suit premises as a tenant on payment of monthly rent. The basis of such declaration was that Ram Sharan Ram, the great grandfather of the plaintiff, predeceased his brother Ram Sevak Ram, who died issueless, and his widow predeceased him. Ram Sevak Ram was carrying out joint family business of hotel in the premises of the Waqf Board. Due to advanced age, he handed over the possession of the hotel business to his nephew Devendra Prasad Sinha, the grandfather of the plaintiff. The grandfather of the plaintiff succeeded to the tenancy as member of the joint Hindu family. After his death, defendant knows. The present position leading to the impugned order has a checkered history. The issue essentially arises under the agreement of sale dated 23/3/2006 entered into between the parties, wherein the appellant is the purchaser, having agreed to purchase the property bearing survey number 35/2. When the position stood thus, the respondent is stated to have got issued a letter dated 9/2/2007 to the appellant directing him to pay the balance sale consideration and secure registration of the sale deed. The appellant had replied to the same on 21/2/2007, raising certain issues relating to the transaction. In that background, the respondent got issued a legal notice dated 17/4/2008 informing the appellant that the agreement of sale dated 23/11/2006 stood cancelled and the advance amount paid is forfeited. The appellant disputed the same through the reply notice dated 5/5/2008, which gave rise to a dispute between the parties. In that background, the appellant was left with no other legal remedy to secure redressal of the grievance and resolution of the dispute. According to the appellant, the settlement though proposed had not fructified, and hence another petition under section 11 class 6 of the Act 1996 in CMP number 228/2015 was filed. When the said petition was listed for consideration on 2/3/2016, the learned senior counsel for the appellant, with the permission of the court, withdrew the petition with liberty to file a fresh petition before the appropriate court, as it was noticed that a petition seeking appointment of the arbitrator was to be filed before the High Court of Judicature at Hyderabad. The learned judge, through the order dated 2/3/2016, placed the submission on record and dismissed the petition as withdrawn with liberty to file a fresh civil miscellaneous petition before the appropriate court in accordance with law. It is in that circumstance the petition in arbitration application number 52/2016, from which the impugned order arises, was filed before the High Court of Judicature at Hyderabad.